Second appeal number 194 of 2006. Where is the appellant is absent? You are further?
This was the notified as the first case which was heard on the last date.
That's right.
Mr. Sarmas is learned senior counsel. So then it is a different
Item
matter.
number 9.
It's the item 9.
Second appeal number 194 of 2006. Nobody appears on behalf of the parties. Although by the order DT.09.12.2025, the matter was directed to be posted for final disposal, today it will be taken up as at 10:30 as the first case. No attendant request has been submitted. However, in order to give one more chance, legal yes or no? The matter is adjourned and is directed to be posted on 6th of April. Subject to payment of cost of at least 5,000 by the appellant. The receipt regarding the cost should be deposited by 16th of January, failing which the settlement shall stand dismissed without further consideration. It is made clear that the interim order has not been extended, let this order be communicated in advance.
This case item 13. Second appeal 106 of 2024.
May it please your Lordship. Lord, this matter was heard by your Lordship on the last occasion. And just to recall, Lord,
Yes.
shall I read out the
Yes, you can.
question for consideration?
You can,
Lord, genealogy.
yes, in all questions.
Now, an outsider claiming Lord himself belonging to the genealogy of the lands in question, Lord, and by pleading in the plaint that there were two brothers of Sukra Dhangad. Sukra Dhangad, हुजूर, हम लोग daughters हैं. हमारे नाना थे सुकरा धांगड़. We the defendants.
You are the defendants?
Defendants. Defendants are appellants before this honorable court.
You are the contesting defendants or the
Contesting. Daughters of Sukra Dhangad. A daughter नहीं मतलब grand maternal daughter Natni. Sukra was our Nana. Now the suit that was filed by the plaintiffs, their prayer is for declaration of right, title and interest and recovery, now this is important, for recovery of possession. Lord. So admitting...
Who are the plaintiffs? Plaintiffs are the?
Plaintiffs are outsiders claiming Lord कि शुक्रा जो हम लोग के नाना हैं वो उनके दो और भाई थे जिसमें एक भाई ठूठा नाम है उसका। ठूठा के वो लोग वंशज अपने को बताते हैं। शुक्रा के एक और भाई थे ठूठा धांगड़ ठूठा। तो ठूठा धांगड़ को वो लाकर जेनेलॉजी में शुक्रा के भाई बताते हुए और एक और भाई हुबरा हरबू धांगड़। तो हरबू धांगड़ कहते हैं कि डायड इंसुलेस और ठूठा से वो लोग अपने को बताते हैं एंड दे आर क्लेमिंग टाइटल एंड रिकवरी ऑफ पोजीशन। Now, Lord, when genealogy is to be proved, Lord, Section 102 Evidence Act, the burden lies on them. It's decided by the Supreme Court also, Lord, which I will just place. 102, Section 102, burden of proof is heavily lies, Lord, because you are introducing yourself into a family. So heavy burden lies. Now here, Lord, no documentary evidence for proving their genealogy. No documentary evidence. And no oral evidence also. Altogether, 3 witnesses they have examined. PW1 himself is plaintiff number 1, Dukhwa Dhangad. PW1, who is claiming and introducing himself to our family.
PW1 is the plaintiff number?
Plaintiff number 1, Dukhwa Dhangad. ये कहते हैं कि ठूठा जो शुक्रा के भाई थे, शुक्रा माने हमारे नाना के जो भाई ठूठा थे, उनका बेटा बड़का धांगड़ से ये दुखवा जो है ग्रैंडसन है,
descendant of
ठूठा, एंड देन ठूठा सन बड़का भी लिख लिया जाए क्योंकि वो इम्पोर्टेंट है। ठूठा का बेटा बड़का और बड़का से फिर ये दुखवा और प्लेंटिफ सब आ रहे हैं बड़का से।
बड़का का बेटा है,
बड़का का ये पोता दुखवा, बड़का का बेटा grandson मिलॉट एंड प्लेंटिफ नंबर 2 फूचू धांगड़, वो बेटा हुआ बड़का का। फूचू धांगड़ इज प्लेंटिफ नंबर 2, वो डायरेक्ट बड़का का बेटा हुआ और ये दुखवा ग्रैंडसन।
He has also been examined. PW2 has been
No.
Plaintiff number 2 has been examined.
Plaintiff number 1 only examined, Lord, as PW1. No other plaintiff examined. Then PW2, Lord, has been examined, and I will just show, Lord, that he does not reveal the spatial means of any knowledge, which is very, very important in the case where a genealogy is disputed.
Who is PW2? A third party.
Garju. Garju Dhangal.
How does he
No.
claim to be related to the plaintiffs?
Not related.
Not related.
Not related blood.
Who is he? What is his introduction as such? What is his locus to
Blood.
depose in this case? Take them.
उसी गांव का बुजुर्ग है.
Just Rajesh, sir, just 5 minutes. The learned senior counsel for the appellant has submitted that the contesting defendants are the appellants before this court. They are the granddaughters of Supra Dhangar,
Who was the only son? No brothers.
Granddaughters of Supra Dhangar, through his daughters. Nathni है ना?
Nothing.
तो through his daughter.
Milord. Daughter दुखनी नाम हुआ.
हाँ, daughter namely Dukhi.
Milord.
The plaintiffs, according to him, the plaintiffs are the outsiders of the family. However, they claim that Sukma Dhangar had two brothers, namely Trutha Dhangar and Habru Dhangar. Habru died issueless, and the plaintiffs claim to be the descendant of Trutha Dhangar. The plaintiff number 1 claims to be grandson of Badka Dhangar, who in turn was son of Trutha Dhangar.
Minus.
The plaintiff number 2, namely Puchu Dhangar, claims to be the son of Badka Dhangar. He submits that.
Three plaintiffs are there.
Yes. And who is plaintiff number 3?
3 है वो डुगिया मुसलमान.
Plaintiff number 3 is Dubia Muhammad,
Wife of Daswa Dhangar.
who claims to be the wife of Daswa Dhangar.
हाँ.
And who is Daswa Dhangar?
Daswa Dhangar, son of Ludo Dhangar.
Daswa Dhangar is son of Ludo Dhangar.
Brother of wife बड़का से ये लोग आया plaintiffs 1 and 2 और बड़का का भाई लूडो से वो है.
And Ludo Dhangar was brother of Badka Dhangar.
This is their genealogy also.
Thus, plaintiff number 1 and 2 are descendant of Badka Dhangar, and plaintiff number 3 is relatable to brother of Badka Dhangar.
Mine.
He has submitted that there is no documentary evidence to prove the genealogy. He has also submitted that even the oral evidence does not support the genealogy of as projected by the plaintiff. The learned counsel has also submitted that altogether 3 witnesses has been examined on behalf of the plaintiffs. PW1 is the plaintiff number 1 himself. PW2 is Garju Dhangar, who is not related to the plaintiffs. And PW3 is?
PW3 Lord is Manoj Kumar Ram.
Is one Manoj Kumar Ram. He is a formal witness.
Formal witness.
He is a formal witness and not a witness of the genealogy.
Proving rent receipt.
For proving rent receipt, and this witness is not a witness on the point of genealogy.
Miller.
PW1 and 2 are the witnesses on the point of genealogy.
Miller.
he has referred to section 102 of the Evidence Act to submit that the burden of proof lies on the person who claims to know the genealogy, and plaintiffs are trying to introduce themselves in the family of Sukkar Dhangra, and therefore it was for them to prove the genealogy.
Milord. The submission for a lordship not
Do you
considered.
see PW1 and 2? What do you have to say on PW1 and 2?
PW1, Milord, PW1, just Milord, he states himself in para Milord 4, I'm just giving para also, in which Milord he says he does not know Sukra Dhangal, grandfather of the Nana Sukra. Sukra का बाप फागु था और फागु का बाप हुआ सुकरा। एक तो सुकरा हम लोग का डायरेक्ट नाना है, नाना के पिताजी फागु और फागु के पिताजी का नाम था सुकरा, वही उसके जेनोलॉजी में भी है। पेज 13 इज द जेनोलॉजी, एक बार उसको देख लें तो फिर बीच बीच में जब भी रेफरेंस आएगा तो दैट बी क्लियर मिलॉर्ड।
The learned counsel has referred to the genealogy as predicted by the plaintiff and is reflected in internal page 3 of the appellate statute.
Milord.
He submits that there are there is one Sukkar Dhangar at the top of the genealogy.
Sukra.
Sukkar लिखा हुआ है, SUKAR.
जेनोलॉजी में मिलॉर्ड।
Sukkar Dhangar, who had two sons, namely Fagu Dhangar, who is a recorded tenant, and Shankar Dhangar, who is also the recorded tenant. Shankar Dhangar died in the year 1935, and Fagu Dhangar, as per the genealogy, had three sons: Sukra Dhangar, Thutha Dhangar, and Hablu Dhangar.
Milord.
He has submitted that PW1 in his evidence in cross-examination. Where is the cross-examination? Which paragraph?
This is Milord cross-examination para 2.
पढ़िए।
फागु धांगड़ को नहीं देखा था। फागु धांगड़ मिलॉर्ड जो ठूठा धांगड़ के पिताजी जिसमें ये क्लेम कर रहे हैं, उसके बाद संगत नहीं होगा, शंकर धांगड़ को नहीं देखा था और सोना धांगड़ को नहीं देखा था। देन दिस इज मिलॉर्ड
सोना धांगड़ कौन?
पार्डन
सोना धांगड़?
सोना धांगड़ हम लोगों को कहीं मिला नहीं, मुझे इस जेनोलॉजी में हम लोग के भी नहीं है, लेकिन शंकर होगा, हो सकता है।
हाँ, शंकर,
क्योंकि शुरू में
आगे फागु धांगड़, आगे पढ़िए।
हाँ, फागु धांगड़ वह सोना धांगड़ के बाप सुकरा धांगड़ मार तो नहीं जानता हूँ।
फागु धांगड़ एवं कहाँ से सोना धांगड़?
तो सोकर
एंड
सोकर या सोना क्या है?
शंकर धांगड़,
शंकर हो सकता है, क्योंकि फागु और शंकर वो यहाँ पर है जेनोलॉजी में। शंकर तो सोकर होता है।
in his इसका चीफ कहाँ है?
चीफ
इतना ही
है,
है ये?
pardon?
इतना ही है इनका?
नहीं चीफ भी हो,
चीफ भी होगा ना?
हाँ
I submitted that in his cross examination. He has stated that he had not seen,
नहीं जानता हूँ,
नहीं को नहीं देखा है. He had not seen Fagu Dhakar and Shankar Dhakar, and he has also stated that he does not know
विराट
the father of Fagu Dhakar and
शंकर ही होगा, जनरली में है शंकर, शोकर लिखा गया है।
सुकर भी नहीं लिखा है।
क्योंकि दोनों फागु और शंकर के पिता हुए सुकर।
Okay, he does not know the father of Fagu Dhakar. उतना सो जाए।
वही करते मिलोट।
इनका शपथ पत्र वाला बयान किधर?
मिलोट। उसी के साथ लगा हुआ।
इसको और भी एविडेंस होगा ना?
In file C of the record, and first the cross examination is there, and then the chief has been. That file C.
File C में cross.
File C में the entire evidences are there. File C from page 1 to 9 of the.
I'm asking the chief. Chief is not there.
Chief, so far the record is concerned, I have seen that chief is also there. First the cross is kept there attached, and then the chief is there.
देखा है तो बताओ। और बताइए PW2 के बारे में आपको क्या पता है?
PW2 मिलोट, it is cross examination para 2. विवादी जमीन का दाग नंबर नहीं कह सकता हूँ, खतियान पर्चा किसके नाम से नहीं कह सकता। Then he admits हमारे बारे में कि बिरसी को कहते हैं कि नहीं पहचानता। And then in para 5 मिलोट, he says कि शुक्रू का बाप का नाम फागु था, शुक्रा का बेटी दुखनी थी, दुखनी का बेटा बिरसी है या नहीं जानता। तो he is also not giving some his evidence firmly मिलोट। And then para 6 is very important of this PW2 कि बड़का धांगड़ को नहीं जानता। हुजूर बड़का से ये लोग क्लेम कर रहा है प्लेंटिफ्स, जो हुजूर के सामने अभी देखा गया।
It is referred to the cross examination of PW2 and has submitted that
प्लेंटिफ्स के फादर का नाम और दादा का नाम है बड़का, कहता नहीं जानता हूँ, पैरा 6 मिनट।
In his cross-examination, he has stated that he does not know the details of the property. Comma, he does not know, he cannot identify this.
Defendant.
Who, as per the genealogy furnished by the plaintiff, was defendant number 1
Murder.
and husband of DT.
Murder.
Semicolon. He states that the father's name of Supru was Padu, and daughter of Supru is Dukhi.
Sukra.
Sukra is Dukhi. Dukhi?
दुखनी का बेटी ये बिरसी मारा, डिफेंडेंट है या नहीं मारा?
But he does not know as to whether Birsi Dhangrai, within that defendant number 1, is the daughter of Dukni or not.
Miller.
He also does not know as to how many children Dukni had.
Miller.
He has further stated in his cross-examination that he does not know Balka Ghangar,
grandfather of plaintiff number 1 and father of plaintiff number 2.
who is
Yes,
and who,
Balka.
as per the genealogy, is grandfather of plaintiff number 1 and father of plaintiff number 2.
My lords. So he is not.
Tisra witness.
तीसरा तो फॉर्मल है, वो तो
So far as the witness number PW3 is concerned, he is a formal witness.
Now, my lord, submission for your lordship's consideration is this: that both the courts, my lord, gave finding of approving the genealogy of the plaintiff, observing, Lord, that in para 12, the defendant number 1, DW1, Birsi Dhamle, in para 12 she admitted कि हमारे नाना सुकरा को 2 भाई थे जिसमें एक ठूठा भी था. Now this is an error of record. Relying on para 12
of DW.
DW1, Lord, who is defendant number 1, Birsi Dhamle. Now relying on para 12, it is Mama.
भाइयों का नाम भी लिए हैं.
हाँ, इसमें आया है,
नाम भी लिए.
भाई का भी नाम आया है,
Two brothers.
ठूठा and Habru. Now this is an error of record, which your lordship may kindly consider.
The learned counsel service said both the courts have approved the genealogy furnished by the plaintiff on the basis, primarily on the basis of,
On the admission, our admission.
primarily on the basis of so-called admission of DW1, within bracket defendant number 1, who is alleged to have stated in paragraph 12 that her nana
Sukra.
in bracket Sukra Dhangar, bracket close, had two brothers, namely Chutha Dhangar and Habu Dhangar. And on the basis of alleged admission, the entire case has been decided.
And
The
generally,
learned counsel has submitted that upon true reading of the evidence of DW1 as a whole, there is no admission as such.
reading para 9 and 13 also.
He submits that the evidence in paragraph 12 has to be read right from para 9 till 13.
Mud.
That's all.
Milord, I place, Milord. Para 12 I place.
Yes.
या पहले जजमेंट से दिखा दे.
मिस्टर तिवारी, अब आपको हम क्या? मिस्टर रॉय को लेकर आइए.
हाँ बिल्कुल
ऐसे हम इस तरह से हम स्टे नहीं करके
नहीं सर हाँ फर्स्ट केस जो चीफ के यहाँ लगा हुआ तब जस्ट खत्म हुआ कि
आप
हम
उनको
कोर्ट हम ले आ रहे हैं सर
ऐसे हमको ठीक नहीं लगता.
हमको भी अच्छा नहीं लगा सिंस दीस पीपल वर आल्सो देयर लिस्ट यूजुअली कंफ्यूजन क्या हो गया सीरियल नंबर 13 में लिख दिया एज अ फर्स्ट केस
नहीं कोई बात नहीं, आप उनको मिस्टर रॉय,
बिल्कुल
हमको अच्छा नहीं लग रहा आपको ऐसे
नहीं।
देखकर.
हाँ सर
I don't like it.
सर
केस मेरिट में हार जीत हो ऐसा.
हाँ बिल्कुल हम भी वही
Yes.
Milord, should I place from the
Yes.
judgment first?
Yes, first the case from this.
Milord. Judgment, page 36 of the appellate court, Milord.
Let us see the issues framed by the court.
Huh?
You are governed by customary law. There is no dispute on that.
Milord, customary law से हम लोग गवर्न है, हम लोग इसको नहीं माने. हम लोग का ये कहना है, उनका एविडेंस आया है प्लेंटिफ नंबर 1 PW1 का कि संथाल नहीं है हम लोग और हम लोगों के इनहेरिटेंस में बेटा बेटी दोनों का ही हक नहीं है. एक अजीब किस्म का उनका स्टेटमेंट आया जो हम प्लेस करना चाहेंगे. क्या कि they have deprived us the trial
So,
court.
the substantial question of law में देखते हैं क्या है.
Milord. Should I read on?
Yes.
Whether the findings of both the courts that the plaintiffs are legal heirs of recorded tenant is based on no evidence, since the deposition of PW1 Dukhwa Dhangar, who also happens to be the plaintiff number 1 and is claiming inheritance from Thutha Dhangar, who allegedly was the son of recorded tenant Abu Dhangar, and the deposition of PW2 Garju Turi as regard the year of death of Thutha Dhangar is highly contradictory. The former states he died in 1988 and the latter states he died in 1980 or not. Whether the findings of both the courts that the genealogy given by the defendants appears to be not reliable or acceptable is perverse in the light of law settled by Honorable Supreme Court in 83(3) SCC 118 as regards the cases where conflicting genealogies are produced by the parties and the genealogies are sought to be proved solely by oral evidence, especially when the PW2 had no special means of knowledge and did not disclose the source, time and circumstance under which knowledge, if any, was acquired, rather his statement contradicted his statement of PW1, and thus the knowledge, if any, stood not clearly and conclusively proved as mandated in the said judgment of the Honorable.
This question of law में misreading of the evidence of DW1 का कुछ जिक्र नहीं है.
आया नहीं है, लेकिन नो एविडेंस करके तो एक आ गया है ऊपर. माने नो एविडेंस, देयर मस्ट बी सम एविडेंस टू कंक्लूड कि जेनेलॉजी जो क्लेम किया जा रहा है बाय द प्लेंटिफ. सो एविडेंस मस्ट बी देयर. तो एक क्वेश्चन तो एविडेंस को लेकर भी है, उसमें एविडेंस आया, नो एविडेंस. whether evidence.
No evidence के आगे तो there it is specifically referring to the evidence of PW1 and it is referring to the evidence of PW2. The question of law is not referring to any misreading of the evidence of PW1. Substantial question of law असर नहीं.
स्पेसिफिक करके नहीं आया हमारा, लेकिन your lordship can very well, because it is something very very glaring, a statement which is not in evidence has been completely misconstrued, and the genealogy
Then we frame
and the genealogy has been said to have
If
been.
that be so, we will frame additional substantial question of law. We can't do it like this.
हाँ तो एक फ्रेम,
जिसका एविडेंस है ही नहीं तो उसका हम लोग क्या करेंगे? जिस एविडेंस का परवर्सिटी के बारे में कोई जिक्र नहीं है
तो उसको फ्रेम, of course my lords can for the ends of justice, because it's a question of genealogy. बल्कि पर्टिनेंट क्वेश्चन एक वो जो हुजूर कह रहे हैं बनना चाहिए था और बनना भी चाहिए. क्योंकि अपलेट कोर्ट के जजमेंट पेज 25 में DW1 जो हम लोग हैं डिफेंडेंट DW1 जिसके एडमिशन पर रिलाई किया, उसी को जब नरेट कर रहे हैं DW1 को अपलेट कोर्ट नॉट इन पेज 25, वो खुद कह रहे हैं कि डिनाई किया हमने.
मतलब आपका सबमिशन
सबमिशन नहीं है, ये इसके अंदर है. तो मैंने अपलेट कोर्ट में while narrating the evidence of DW1 in page 25 lord, the court finds कि DW1 the defendant has denied कि उसके दो भाई थे उनके नाना. So himself when narrating DW1, it has come in the appellate court lord that she has denied कि हमारे पिता के दो भाई थे. Para 9 is also referred कि एक लौते थे हमारे पिता. ये सब appellate कोर्ट में ही आया है. Page 25 lord. इधर पेज 15 है.
Where is the finding?
Lord, finding page 36, Lord. Internal
The court
26.
is taking into consideration all the evidences, not only that is not the solitary reason for giving that finding.
Lord,
That is not the solitary reason for giving
page
that finding.
36 में kindly see, Lord. Page 36 में towards the middle, Lord. It is the defendant DC Dhanglin DW1 who has stated in para 12.
नहीं, आप ऊपर से पढ़िए ना, आप उतना सिलेक्टिव मत करिए।
हाँ पढ़ते हो ऊपर से।
ऊपर से। In the written statement.
In the written statement, the defendants have
नहीं,
averred.
आप उसे पूरा पढ़िए, para 18 पूरा पढ़िए।
Page 35, Lord.
Yes.
Lord. Findings on the point of for determination 2. Whether both the parties are the common descendants of recorded tenants as per their genealogy or not, and who was in possession of the suit lands earlier to 1/8/2002. This point is most important point to decide the case. After perusal of the pleadings and evidence, oral and documented, adduced on behalf of both the sides on the case record, it appears that admittedly the suit land described in Schedule A, B, C, D of the plate are recorded in the name of Fagu Dhangar, Exhibit 2 and Exhibit B. Fagu Dhangar and Shankar Dhangar, both sons of Sukra Dhangar, Exhibit 3. Fagu Dhangar, Exhibit 4 and Exhibit D, and Fagu Mandal and Birsa Mandal, Exhibit 5 and Exhibit E. The genealogical table given by the plaintiff is showing the names of all the recorded tenants in the suit land. However, the genealogical table given by the defendant is not showing the names of recorded tenant Birsa Mandal, son of Tetu Mandal. Apart from this, the genealogical table mentioned in the written statement and the mentioned in the oral evidence by way of affidavit of DW1, Birsi Dhangle, are different in the written statement. The defendants have averred that Dukhni had 5 children, whereas in her evidence by way of affidavit, the DW1 has deposed that Dukhni had 4 children. This shows that DW1 is not sure about her own genealogy. Hence, the genealogical table given by the defendants appears not reliable and acceptable. The defendants have averred that RT Fagu Dhangar had only one son, Sukra Dhangar, whereas plaintiff's averment is that recorded tenant Fagu Dhangar had 3 sons, Sukra Dhangar, Chutha Dhangar and Habru Dhangar. PW1 Dukwa Dhangar has stated in para 12 of his examination in chief that Fagu had 3 sons, Sukra, Chutha and Habru. PW2 Ganju Turi has stated in para 12 that he had seen Chutha Dhangar, who died in the year 1980. Chutha Dhangar was son of Fagu Dhangar. On the said points, both the above PWs have neither been cross-examined nor the facts have been denied in suggestion.
Pause for a moment. Right. There has been no cross-examination of these 2 witnesses on the point which has been stated in this particular judgment. We have not seen that chief, right? So, if PWs are making some statement and if there is no cross-examination on that, then under such circumstances, how do you figure out from there?
My Lord, the admitted case in the plaint of the plaintiff says that Birsi Dhanglin, which we are, my Lord, is in the genealogy and is descendant of Sukra Dhangar. Now this is admitted by them.
Yes.
And they also admit in the plaint कि हम लोग दखल में हैं. Recovery of possession has been prayed as one of the reliefs. Recovery of possession. Now, my Lord, here what the appellate court has urged, my Lord, is the facts which are admitted in the plaint. I mean, I need not prove that and cross-examine. It's an admitted fact that Birsi and the defendant blood belongs to this genealogy and the recorded tenants. Question was before the courts below.
No, the two witnesses of the plaintiff has deposed about the relationship, and there is no cross-examination on that point.
Lord. And it is a settled law by decisions also, Lord, that the plaintiff has to prove its own case. Cannot take advantage of. First you prove, and then this is what, Lord, your lordships have said, Lord, and High Court and the Supreme Court, कि उसके बाद तब फिर उस पर बर्डन आएगा, पहले तो आपको प्रूफ करना है. So initially the burden lies on you. You discharge your burden, my lord. Now here the plaintiff has not discharged simply the statement of on PW1, my lord, the plaintiff, the finding has been given and relying on an admission which is not an admission by DW1. She never admitted, my lord, because para 12 हम रिप्लेस करना चाहेंगे एक बार, उसके बाद para 9, 13 वगैरह सब तो साथ में है ही. लास्ट ओकेजन पर भी हमने उसको माइनॉर्स के सामने रखा था. इसमें देखा जाए para 12 में of DW1. Para 12 में लॉर्ड,
DW1 का नाम क्या है?
बिरसी नाम है. Defendant number 1. para 9 से पढ़ देते हैं.
हाँ बताइए.
para 9 फागू धांगड़ को मेरे नाना सुकरा धांगड़ के अलावे कोई औलाद नहीं थे. He was the only son. Then Lord para 10 हबरू धांगड़ का नाम नहीं सुना है. 11 सुकरा धांगड़ एक ही भाई था, ओनली सन. इसका मेरे पास लिखित कोई कागज नहीं है. देन लॉर्ड पैरा 12 मेरे नाना को 2 भाई और थे, ठूठा धांगड़ एवं हबरू धांगड़. उसके बाद कॉमा है उधर. ऐसी बात नहीं है. In cross examination a suggestion was thrown कि क्या ऐसी बात है, तो उसी को करें, क्योंकि कॉमा के बाद ऐसी बात नहीं है करके फिर पूर्ण विराम आ जाता है, फुल स्टॉप. और उसके बाद है कि मैं ठूठा धांगड़ एवं हबरू धांगड़ का नाम पहली बार सुनी. So it's not admission. दो भाई थे ऐसी बात नहीं है, कॉमा करके है और उसके बाद फिर फुल स्टॉप आ जाता है.
फुल स्टॉप भी नहीं है ना.
फुल स्टॉप ऐसे करके भी आता है.
नहीं सर. हाँ हम लोग
या जो भी हो, Lord, for your kind consideration, because it has to be read in the whole, and then while narrating her evidence, Lord, in page 25 of the same judgment,
आगे बढ़िए 13-14.
तेरा वादी मेरे खानदान के नहीं है, मेरे नाना सुकरा के खानदान के ढूंढा धांगड़ ठूठा धांगड़ एवं हबरू धांगड़ नहीं है. My lords. So specific statements, categorical statement are there. He was only son, no brother, और ये दोनों भाई नहीं थे. And relying on this, my lord, or misconstruing, of course, for your lordship's consideration, my lord. Now on this, relying on para 12, my lord, the genealogy has been approved. Though there is no evidence as such given by the plaintiffs, my lord. Because PW2 is a very perfunctory sort of statements have come. He himself has no knowledge of the family also. Sometimes he says yes, sometimes no. And then he goes to the extent PW2 my lord कि बड़का को हम नहीं जानते हैं और बड़का से ही ये लोग क्लेम कर रहे हैं plaintiffs. So therefore PW2 my lord also is not supporting PW1. So no evidence by the plaintiff for proving the genealogy.
ऐसी बात नहीं है कि मैं ठूठा ढांगड़ और अमरूद ढांगड़ का नाम पहली बार सुनी हूँ. ऐसी बात नहीं है सर, मैं ठूठा ढांगड़ और हबरू ढांगड़ का नाम पहली बार सुनी.
9, 10 वगैरह सब paragraphs to move as a whole in harmony. If your lordship will construe, of course, we always, for your kind consideration, Lord, because एक पैरा से नहीं होगा, ऊपर में भी कई पैरा है.
ट्रायल कोर्ट का क्या फाइंडिंग है सर?
ट्रायल कोर्ट का भी वही रिलाई करते हुए उसने कह दिया genealogy has been proved by the plaintiff. Page 60 पर है, page 60 of the trial court. उसने जेनेलॉजी को मान लिया पैरा 12 का हवाला देते हुए कि एडमिशन है और उसके बाद हम लोगों को भी हाफ शेयर दे दिया ट्रायल कोर्ट. एंड दैट हाफ शेयर आल्सो हैज बीन रिवर्स्ड बाय द एपलेट कोर्ट सेइंग कि आपका घर जमाई शादी नहीं हुआ. तो घर जमाई वगैरह ये सब संथाल में उजूर होता है. स्टेटमेंट PW1 जो प्लेंटिफ है उसका स्टेटमेंट आया कि हम लोग संथाल नहीं हैं, और बल्कि ये आया कि हम लोगों में बेटा बेटी दोनों को ही हक नहीं मिलता है. A very absurd sort of statement has come from him, which if you lot will, I can show that paragraph also.
Mr. Banerjee, paragraph page number 26 of the appellate court's order. Right?
Paragraph
36.
yes, of the Learned First Appellate Court.
Paragraph number
18, that is.
18. Right? Yes.
It is while determining the point of determination number 2.
That's right. Just a minute. They have picked up paragraph 12.
But
Both
one
the
thing,
courts.
but one thing is there. The judgment is not an admission with aid of section 58 of the Evidence Act because it is in totality. If I first read out the judgment of the learned first court, there is a case where there is a
You
concurrent.
see, the evidence of PW1, PW2 is already in cloud because there is a specific substantial question of law.
Only with respect to the year of death,
Not, yes.
only with respect to that. Only,
That's
only,
right.
only.
Not only, no. The findings of both the courts are the legal, is based on no evidence. Right? It's based on no evidence. This is what-
And it is then it is said that since, and that is because of the reason that the date of death is differing as per the two witnesses. That is since the deposition. May I just submit?
You see, when we see, have both the courts considered the evidence of DW1 in totality?
Yes.
What happened, you see, para number 12 is apparently a mystery. We just read para 12.
Yes.
And para 12 cannot be read in isolation.
Therefore,
The relationship is coming right from para 9 till para 14.
yes. Therefore,
And therefore, the whether the courts have committed perversity in reading the judgment, reading the evidence of DW1 is also an important aspect of the matter. The entire genealogy depends upon the evidence of the plaintiffs and the witnesses and the defendants.
here is a case. It would have been certainly it would have been a relevant consideration. Had that would have been the only consideration. Here is a case where in the learned first court as also the learned appellate court.
The evidence of the other witnesses are also required
Also,
to
it
be
is-
seen. That is within the framework of the substantial question.
The first court and the second court has considered the evidences on record in totality, and it is not that merely on para 12 reliance has been placed.
Apart from para 12, has the court referred to any particular evidence of the DW1?
That is.
There is no reference.
First court, if not, if
No,
if
first
this-
court, it is almost a copy paste.
first court says there is a concurrent finding
The
of fact
concurrent finding of fact based on copy paste.
because it is on reading of the
No, you
evidences.
just show me. Is there any discussion of the finding of the learned first appellate court itself is contradictory? Because at one stage the court records as to what this DW1 has stated, and in the finding this is what the court
And-
writes.
And
You
there,
just see, is it not contradictory?
it is there. I have seen. So far as the recording of evidence. Now, only thing which I intend to submit is that this is a judgment, not an admission, not purely an admission. Then it would have been a question of
That
law.
we will see. What
Because it is a.
You see, if there is one piece of evidence which has been taken into consideration to come to a finding, there can be a situation that bereft of that particular evidence, still the judgment may sustain.
Yes.
There can be a possibility.
Yes. That I am
But at the
submitting.
same time, there can be a possibility that bereft of that evidence, the judgment may not sustain. So
Yeah.
for that purpose, an additional question of law is required to be made. Because I'm on the face of the evidence of this DW1. The evidence of
On-
DW1 has to be taken in totality.
And now the
It's not a statute, you pick up one section and do not read the other section, or it can't be. The evidence has to be read as a
now
whole.
on that the cross examination of the plaintiffs done by them. So far as that would be relevant, reading that.
Everything will be read.
What questions they have put? There is not a single question with regard to tutor. There is not a single
Which
question
is-
during the cross examination, meaning thereby
Cross-examination, we will see the cross-examination of DW1.
because that means
But so far as DW1 is concerned, the evidence of DW1, only paragraph 12 has been picked up. That is also a misreading of paragraph number 12. And rather, the entire evidence was to be taken as a whole.
it is certainly the entire evidence has to be seen.
Then-
But again, for the sake of repetition, I would say that had it been a case that where the judgment is based on evidence with aid of Order 12, Rule 5 and Section 58 applying the principles of evidence, it is not a case. Here the learned first court, the learned the learned first appellate court has not only considered that aspect. They have
See,
considered
there could
totality.
be a situation that irrespective of the evidence of DW1, the judgment may sustain.
That part of
But-
that evidence.
but
That
unless-
part.
Unless we appreciate that, we will not be able to do it.
That part, because it is a finding of fact and consistent finding of fact
But still, the substantial question of law has been
by
framed.
both. Now the
Still, the substantial question of law has been framed.
the substantial questions of law which are there, which this honorable court has already seen.
We will
Which,
not narrow down the substantial.
yes, now the
question of
substantial
law.
questions which are there on record, it is basically that whether it is based on no evidence, that the plaintiffs are legal heirs of the recorded tenants is based on no evidence. Now there is no cross-examination of the plaintiff number one who has examined as plaintiff's witness number one on the aspect of that Thuta is a stranger, he was not a son. There is no cross-examination, no question to that effect. Meaning thereby the pleadings which the plaintiff number one sought to prove by way of his evidence, that has not been questioned. That is not their line of cross-examination. And one part, there were two aspects. One was the genealogy, whether they are of the same family. Our case was that yes, they are also of our family, and their case was that we were stranger. On that, there is a concurrent finding on that. Now the other aspect is about succession. On that, there was a reversal by the learned first appellate court, and then considering our cross objection, first instance, considering our cross objection in the appeal, the learned first appellate court has come to a finding that since it is an admission by them that they are governed by the customary law, tribal customary law, and so they are not entitled on that part. So there also that part that part only there is a reversal or difference of opinion between the first court and the second, the learned first appellate court. And so far as the first question of
You
law.
listen to the order. SC number 106 of 2024. At this stage, the learned counsel for the appellant has submitted that a substantial question of law is involved in this case in as much as both the courts have misread the evidence of DW1 and the evidence of DW1 was required to be considered on the point of genealogy was required to be considered as a whole, particularly paragraph 9 to 14. 9 to 14. He has also submitted that even with respect to paragraph 12, there appears to be misquoting. The learned counsel has also submitted that it is certainly to be seen by the court as to whether the genealogies to prove on the basis of the oral evidences adduced by the parties. And the genealogy produced by the plaintiffs or the defendants to prove on the basis of the genealogy or on the basis of the oral evidence. But an additional substantial question of law in connection with appreciation of evidence of DW1 is required to be seen. He has also submitted that in the appellate court's judgment, it has been stated in internal page 15 that in paragraph 12, the DW1 had denied that her Nana had two more brothers, Thuta Dhangar and Habru Dhangar. But while recording the finding, it has been stated that DW1 had admitted that her Nana had two brothers, Thuta Dhangar and Habru Dhangar. The first appellate court's judgment itself is self-contradictory. The learned counsel for the respondents has opposed such a prayer and has submitted that, irrespective of evidence of BW1, the genealogy projected by the plaintiffs stood proof inasmuch as there was no proper cross-examination of the plaintiff number 1 and 2. That's all.
And the important thing is that the judgments of the learned first court and the learned first appellate court is not based upon admission so far as para 12.
And he has submitted that the judgment of both the courts is not based on admission of DW1,
DW1 so far as particularly para 12 is concerned.
particularly paragraph 12.
It is upon consideration of the
That's
entire evidences in totality.
And the entire evidences have been considered in totality to come to a finding.
And there is a
At this stage, considering the arguments of the parties on framing the additional substantial question of law involved in this case, this court finds that both the courts have certainly relied upon paragraph 12 of evidence of DW1 and the other related paragraphs, right from paragraph 9 to 14, appears to have been ignored. Further, the judgment passed by the learned first appellate court is self-contradictory when it refers to the evidence of DW1 at page 15. Her denial has been recorded in paragraph 12, and at page 26 her admission has been recorded in connection with same paragraph 12 of her evidence. Accordingly, a substantial question of law does arise for consideration in this case to the following effect: whether the learned courts have committed perversity in appreciating the evidence of DW1 by 9 to 14 should be sufficient. By not considering the evidence in totality in paragraph 9 to 14, you want to continue today or you want to start?
It will better just some time may be given so that we can come out with proper.
This is required to be considered. You can't shut down.
Because
Anyways, I have passed an order.
that is there. That is there. But perversity may be a question of law. But so far as
It
the
is
factual aspects,
We'll see
it may be a things to be considered ki whether it will
We will
fall
see
within the
that.
ambit of substantial question of law or not.
This
That may be.
perversity is a substantial.
The perversity, but whether this amounts to
Yes.
perversity, because what
I
it is.
have passed an order. If you want to challenge it, you may. I'll give you some time. And if you don't want to challenge it, we can. It is absolutely self-contradictory. We can reconcile. At one stage he is writing that she is denying, and at the other stage he says that there is an admission, the same judgment.
But therefore,
therefore-
anyhow, that order has been passed on question of law that it will be futile to make any further arguments
Yes.
or any assistance on that.
When you know.
Let it come in January 2nd or 3rd week.
In the meantime, your stay was granted by my lord
I will grant you
of the
stay.
execution. But still,
Just a moment. upon framing of additional substantial question of law, इसका जो paragraphs है ना, 9 से 14 हिंदी वाला quote करते हैं, in हिंदी only, कुछ नहीं करना, जहाँ कॉमा है जो है एकदम कॉमा full stop टाइप करते हैं, because that will help you. At this, upon framing of the additional substantial question of law, the learned counsel for the respondents prays for adjournment. The summons said the matter be posted on, बताइए,
Whenever it is convenient to this on report also.
on 28 January. Post on 28 January for further hearing.
In the meantime,
In the meantime, till 28 January, the interim order dated
28/11/25.
28/11/25. Shall I continue? Yes, Mr. Roy, are you there? We recall that order.
Item 9, second appeal 194 of 2006.
Sir.
Filed under IA note 16331 note.
The order has been passed on the time, 16.
16331 note.
What
This
is
is for additional substantial question.
additional substantial question? What is it that you are proposing?
Lordship. That is at PhD Lordship AN.
Yes.
It is misinterpretation of document Lordship. Both. We also Lordship because exhibit 4 the sale deed is also misinterpretation of the documents. And we have a direct judgment on that one. Since Lordship the entire case hinges on the permission under section 46. That is
What is exhibit 3 is the order of permission and
Lordship
section
46.
46.
And exhibit 4 is followed by the same. Now Lordship, the entire case of the plaintiff, just for a short Lordship,
Yes.
that 15 disputes of land, 15, 15 and 30. We are concerned with only 15 disputes of land. The case of the plaintiff is that 30 disputes of land, 15 in plot number 735. That is what this defendant number 1 was concerned with. Permission was given.
You are ready for this?
Yes.
Yes.
The permission was given by the defendant number 2 that the 15 disputes of land of plot number 735 is to be sold. That is what the case is.
15 dismissal of block number
735.
730, which is a new property.
Suit property is much more Lordship, but we are only concerned with 15 disputes because the other defendant had accepted the sale deed and the exhibit 3. I am not concerned with that. He may accept whatever he does. He may compromise. He may not fight the suit. He may relinquish
Then-
his
then
portion.
What is the perversity in this?
Lordship. Now this exhibit 3, Lordship will kindly find from the exhibit 3. It is only for 0.15 decimals and not at one place, at two places. Even the sale deed, that is for 0.15 decimals. But the map attached relates to 30 decibels.
आप 10.50
10.50
पैसा देते हैं?
10 point
Rupees 10.50 पैसा. You see this.
10 रुपए 50 पैसे.
Invariably, you forget about that. That's
Not
not a
sure,
correct
not sure.
example. Invariably, right? ये 0.15 डिसमिल जो लिखते हैं ना ये लोग, ये एकड़ डिसमिल में ही होता
वही तो जो कहना चाह रहे हैं. अगर ये एक्चुअली डिसमिल होता तो 0.15 एकर्स होता, और अगर डिसमिल में लिखते तो ओनली 15 डिसमिल्स लिखते. And that has been discussed by the trial court, the appellate court also. And they have presumed कि नहीं इसको हम मानेंगे 15 डिसमिल. Or it is not at one place, and therefore, Lordship, that is the substantial question of law because it is construction of the document.
You were the defendant.
I was the defendant, Lordship.
What was your case in the written statement?
My case in the written statement is
What permission was there?
permission.
Is it admitted that there was a permission?
Since Lordship, we are the purchaser.
Was it admitted that there was a permission?
The person, Lordship, who has given the permission has never come before the court.
Need not come. If it is an admitted fact, we don't need to bother about anything. Who has
Yes,
come,
yes.
has not come.
That is an exhibited document,
Not, we forget about the exhibit.
Lordship.
Is it an admitted fact that there was a permission?
There was a permission. With the permission, subsequently the sale deed.
Subsequent to
Sale.
sale deed,
Yes.
right?
Yes.
It is not in dispute that permission, that sale deed was backed by a permission.
No. Permission, then sale.
Yes.
Yes.
Sale deed was backed by a permission.
Yes. Sale.
So why do you want to interpret this in this manner?
Since Lordship, that is what the document says. I just want to show the document, Lordship.
Was it your case that there was a permission for only 0.15
No,
decibels and
since-
therefore the sale deed was in excess of
Lordship, what I am
this?
submitting, when the print was filed, earlier, Lordship, it was not supported with the document. Now, only after the same were exhibited, then only we came to know an entire argument is based on that.
You are
We are the defendants.
the purchaser of the property.
We are the subsequent purchaser in 1990.
1990.
This purchase was in the 1983.
Okay. This is 1983.
Lordship.
You are the
1990.
purchaser?
1990.
90. Okay.
Out of 46
In the sale deed of 1983, the permission must have been mentioned.
that the permission is also mentioned, and the area of the property has also been mentioned. That is not in dispute. Dispute is only with respect to how this has to be read, because it is a construction of the document, Lordship, has to be read in totality.
Just a moment. If you are the purchaser of the property, you are a beneficiary of this permission.
No. हमारा तो बाद में permission हुआ. Same person, defendant number 2, first, according to them, first gives permission to them, sell some property, and then again in 1990, same permission was from the same plot, that is 735A. Now why A comes? There was one partition in the 1946, and the person who has granted permission, his father was allotted. Out of 735,
What is the
735A,
total area of 735?
735 is, Lordship, about 2 acre 10 decibels. And now 735A comes. जो partition में 1946 में grandfather इनके father को मिला, the person who has sold, that is 46 decibels.
46.
Yes, Lordship. And out of this 46 decibels, according to the plaintiff, they purchased 15 decibels.
15. And how much did you?
And we have purchased 34 decibels. Now the another question arises. अभी भी हमारा 31 decibel बचेगा अगर हम उसको ऐसे भी लेते हैं तो 3 decibel ही होना चाहिए. But now the pleader commissioner reports come. The pleader commissioner says the entire 15 decibel is comprised in that 34 decibel. It is entirely overlapping.
What do you say?
Yes. Your ladyship correctly pointed out what is his case. The case of the plaintiff, so far as I am concerned, I am the plaintiff respondent. There are 3 defendants. Defendant number 1, my learned friend is representing. Defendant number 2 is a purchaser of plot number, subsequent purchaser of plot number 730. Defendant number 3 is the vendor, common vendor.
And who is defendant number 1?
Defendant number 1 is subsequent purchaser, son-in-law of defendant number 3. My case is
Just a minute. Defendant number 2 is the purchaser. So all the
subsequent purchaser,
subsequent-
and she accepts my sale deed. She accepts my sale deed.
1 and 2 both have subsequent purchase.
Please hold. Yes.
Case of the plaintiff is that after due permission under section 46, she purchased 30 decimals from plot number 730 and 735, 15 decimals each, comprise 15 decimals in
730 and
735
735, 15 each.
each from defendant number 3 after due permission.
Huh.
She was put in possession subsequently around 91-92. She was dispossessed.
What is the date of this sale?
My sale deed is dated. Exhibit 4 is dated.
Exhibit 4.
Issue
Exhibit 4.
19.
That is not stated. 31/5/1982.
Then 1991-92 she was dispossessed because of the
The
defendant.
subsequent
subsequent
sale deed.
purchase.
Subsequent purchase, she filed an application on the 71A. In that proceeding, she came to know about the subsequent sale deeds. Thereafter, the suit. Case set out by the defendant number 1. Defendant number 3, the vendor did not contest, though appeared did not contest. Defendant number 2 accepted my sale deed. She said, yes, plaintiff had rightly purchased 15 decimals of. Defendant number 2 is concerned with only 730. So she accepts my sale deed. Contest is only with regard to defendant number 1. With regard to plot 735.
Now, defendant number 1 also purchased both the plots.
No, 735.
7. Okay.
The case set out in the written statement is that the defendant number 3's father.
Defendant number 1 and 2 had 5 different written statements.
Yes, different.
And defendant number 3 also filed a written statement.
Did not contest.
Did not contest. Okay, fine.
Now, case set out by the defendant number 1, your leadership will get from internal page 4, but briefly what I. His case is the defendant number 3's father had instituted a partition suit against his brother. The suit was decreed. The pleader commissioner submitted a report in that partition suit in which his share was carved out and 735A was his share shown in tracemark. So he did not have any did not have any title over 735. Whereas 735 as comprise what is mentioned in my sale deed is from RS record of rights. A pleader commissioner while preparing a takta for sake of convenience can make 735A, B, C because तीन share होना है उसमें. तो that is his case कि नहीं 735 में defendant number 3 को कोई right ही नहीं है. तो बेच ही नहीं सकते.
It was not his case that.
हाँ वो anomaly in the sale deed what he's trying to say.
Normally in the sale deed or
The area.
normally in the permission and the
Yes,
sale
yes.
deed.
That was never his case. And your leadership will find from para 31 onwards of the first appellate court judgment that exhibit 3 and 4 has been dealt with in details. In some portion, in the main portion, it is written 15 decimals. कहीं 0.15 decimals हो गया, but in the main portion जहाँ पे होता है schedule में map with dimensions को भी compare किया गया, it is 15 decimals.
So these documents have been fully considered.
Fully considered, and this does not even constitute substantial question of law.
Lordship will kindly come may see those documents because what Lordship my learned friend is saying, whatever the print was, we have replied to the print because since these documents were not at the hands at the time of the print when the print was given as a notice to us, and at that time Lordship no document was used to be filed. Now Lordship
That did
we
not
kindly
prevent them from filing an
Because-
amendment
because-
if required.
Yes, Anita.
No,
The moment you see the things which you have not addressed in your written statement, your this kind of plea will be beyond your.
no. This is all come in the argument.
No, it might have come
In
that,
both the-
but it
in
is
both the
beyond your
courts,
pleading.
Lordship, they
You
have
see, the
considered these
execution-
things.
The execution of the first sale deed is not understanding. There was a sale deed, there is no doubt on that.
Then Lordship, I'll come to Exhibit 4. That is a DCLR's order, Wherein Lordship, one more person.
Exhibit से केस नहीं बनाइए, writ petition नहीं चलता, आप अपना plain written statement से case
Lordship,
बनाइए. And if you have to take something glaring like this, your written statement should have been amended accordingly.
Lordship, what I am
Beyond that, beyond pleadings, we will not come.
Leadership, may kindly take para 32 of this. 32.1 is very relevant for the purpose and inference of fact from recital of contents of a document is a question of fact.
I have a different judgment on that.
No, we will, you see, if you have not joined issues,
Since Lordship, those
On
are the
the basis
consideration,
of
that is the
plain
only
and
consideration, Lordship.
beyond pleadings, this is a plea beyond.
Lordship, since right from para 19 of the appellate court judgment till Lordship para 44.
You might have.
From 19 to 44, Lordship, the entire consideration on this is the only fact, Lordship. And this judgment, Lordship, I am relying upon. The misconstruction of the document. That is a substantial question of law, not cannot be said to be a substantial question of law based on facts. That is, Lordship, those paragraphs, Lordship, I am just referring.
Principles with regard to additional substantial question of law is leadership is recent judgment, 2025 judgment. 18.1 is relevant.
Para 10, 11, 13 and 17, Lordship, in my judgment, Lordship.
2025, this is
Para number?
18.1. In above background, we examine the procedure followed by High Court. A few precedents on the point are noted. The principles emanating from the precedents of section 100 clause 5 of CPC can be summed up as follows. A substantial question of law must be grounded in the parties' pleadings and findings of law.
Is it based on your pleadings or yet it is not based on your pleadings? Yes?
Lordship.
Whatever you are proposing, is it based on your pleading or it is not based on?
Lordship, Lordship, may go to paragraph 17 of my judgment, Lordship. It is the misinterpretation. Entire document what was produced.
No, I just want to know.
Because
Whatever additional substantial question of law
what
you are
I am
proposing,
submitting, Lordship, yes.
whatever additional substantial question of law you are submitting,
Yes.
is it based on the pleadings of the party or it is not based on the pleadings?
It is not on the pleading, Lordship, but their pleading also does not corroborate with the documents which they have provided. They say 15 decibels. That is my case. If I do not appear, if I do not
They
object.
say 15 decibel in their case.
Yes.
Yes, this is what their case is.
But that is not the 15 decibel of land.
That's right. They say 15 decibel.
That is the
You do not
misinterpretation of
dispute
documents,
15
Lordship. They should come with the 15 decibels of land, I will be out of the court, Lordship. I cannot say anything because a previous transaction is there. Lordship may kindly come to paragraph 17, Lordship. That is important,
See, if
Lordship.
it is not based on your pleadings, we will not find
It is not based on my pleading, neither it is based on their pleading. The pleading not supported with the document. That is my case, Lordship. And that is required to be decided, Lordship.
Para 17.
Lordship. Thus, when, Lordship, this from judgment, Lordship, I am just construction of the document, Lordship. That judgment just I provided, Lordship. 2007, volume 5.
Para 17.
Para 17, Lordship.
So I find that DW1 is equal.
Lordship, paragraph, my judgment, Lordship, which I have just provided.
Okay,
2007, volume 5 is this.
Para number?
Para number 17, Lordship. More paragraphs are there, Lordship, but this is the important part. This says that it is a substantial question of law.
Yes.
Thus, when the court below misread and misinterpreted a document of title, read with other documents, we have both the documents, and the plan for the identification of the suit lands, whereupon the plaintiff themselves relied upon, a substantial question of law arose for determination of the High Court in between the parties. Because that is the document which they are relying. I need not require to prove anything. It is only on their document. If they prove it is 15 decimals, I am out of the court. That is only my submissions.
Mr. Law, you show me that the entire facts and circumstances were taken into
Yes,
consideration.
para
And it is
31
not
onward.
based on just that.
Para 31.
That
Appellate court.
yes.
Yeah, appellate court.
Para 30, in this appeal, careful appreciation of documentary evidence would be very decisive to decide the issue. Now I take up the documentary evidence. Before that, your ladyship, the oral evidences were considered and the oral evidences of the plaintiff with regard to Exhibit 3 and 4. Firstly, I take up document of plaintiff's right. Exhibit 3 is the certified copy of order dated 24/5/82 passed by the rent suit decree collector Ranchi in case number M334/8081 under 46 of the CNT Act, whereby permission was granted to defendant number 3 to sell the land to Mary Tigga and also to one Quality Tigga. In this connection, it is submitted by learned lawyer for the appellant. As Exhibit 3 shows, sanction for transfer was granted to D3 to sell only 0.15 decimals of plot number 730 and 0.15 decimal of plot number 735. In this connection, it is submitted by the learned lawyer for respondent number 1 that it was only due to arithmetical and clerical error, as it would be evident from perusal of the entire Exhibit 3. It was also submitted by him that the intention of D3 to sell 30 decimals of land, and he also applied for sanction to sell 30 decimals of land. Now it has been mentioned in Exhibit 3 that Benedict Thalko wants to sell land of his father, and that after transfer of land by Benedict, 1.5 acre of land would be left with him. Now Exhibit A, that is decree of partition suit number 144 of 49, which shows that Somarao Rao, father of D3, was allotted lands mentioned in schedule of the lands allotted to him. So if compared with Exhibit A, the finding in Exhibit 3 that after transfer 1.5 acre would be left with D3 goes to show that sanction was accorded to D3 to sell 30 decimals of land and not sale of 0.3 decimal of land. Secondly, Exhibit 3 shows that the proposed consideration was Rs 3,000 in May 1982. So if consideration is compared with consideration mentioned in the sale deed of 11/4/1994, Exhibit 1 of Division 1, it can only be inferred that Exhibit 3 sanction was accorded for 30 decimals of land. Exhibit 4, the sale deed dated 8/4/83 executed by Benedict Thalko, D3 in favor of plaintiff Mary Tigga. In this connection, it was submitted by the learned lawyer for the appellant that the sale deed, Exhibit 4, also in the column of description of property, it has been mentioned as area 0.30 decimal, and it was submitted only 3 decimal of land was transferred by T3 to the plaintiff. In this connection, it was submitted by the learned lawyer for the respondent 1 that construction of document, the intention can be gathered by construing the document as a whole, and a stray sentence cannot be allowed to be picked out to construe a document, and that it is apparent from recital of Exhibit 4 and the sketch map annexed therewith that 30 decimal of land was transferred to the plaintiff by Exhibit 4. In support of his contention, the learned lawyer for R1 relied upon the decision of AI 1987 Kerala 84. This reported decision has been held as follows. A document has to be construed as a whole. A stray sentence here and there cannot be picked out to construe a document. To understand the tenor of the document and the intention of the parties, it has to be read as a whole. The real intention of parties has to be gathered not merely from ex parte as stated in the description of the property in the schedule, but from
Essay number till 44.
till 44.
Essay number 194.
Yes, 194 of 6. 2006.
With IA number 16331 of 2025. The interlocutory application has been filed for claiming additional substantial portion of law. The learned counsel, which are as under. The learned counsel for the appellant has submitted that the courts have misconstrued Exhibit 3, which it was the permission granted under Section 46 of the Tobacco Tenancy Act, and consequently Exhibit 4 also, which was follow-up sale deed He submits that the permission was granted for sale only with respect of 0.15 decimal in khata number 735.
Plot, that is plot number.
Sorry, plot number 735.
Khata number 137.
The khata number is not required.
अच्छा ठीक.
Sir, in plot number 735 and 0.15 decimal in plot number 734.
No, 15 decimals each in 730 and 735.
Oh, 730 and 735. He submits that once the permission was only for 15 decimals each in 730 and 735.
0.15 decimals.
0.15 decimal in plot number 730 and 735 each. Then under such circumstances, the claim of the plaintiff that 15 decimal in each plot was sold is not in accordance. He submits that these two documents have not been properly examined by the court and therefore a substantial question of law as aforesaid arises for consideration. He has also submitted that misinterpretation of document by itself constitutes a substantial question. For this purpose, he has relied upon the judgment passed by the Honorable Supreme Court, reported in bracket 2007, bracket close 5, SSC 669, para 17, which reads as under. When thus the court below misread and misinterpreted a document of title read with other documents and the plan for the identification of the suit land whereupon the plaintiffs themselves relied upon, a substantial question of law arose for determination of the High Court in between the parties to the suit. Inverted commas. The learned counsel for the respondents has opposed the prayer and has submitted that the discrepancy with respect to the area as referred to in Exhibit 3 and followed by the same Exhibit 4 has been duly considered by the learned First Appellate Court, taking into consideration both oral and documentary evidences. He has submitted that the documentary evidences in particular have been considered in paragraph number 31 to 44.
44.
The learned counsel has also submitted that upon complete reading of these paragraphs, it reveals that the learned court has considered every aspect of the matter and the intention of the parties, and under such circumstances, no additional substantial question of law.
Moreover, there is no foundational pleading with regard to the
He has
search
also submitted that there is no foundational pleading
in the documents.
in the written statement questioning the permission or the sale deed with respect to the area involved in the permission and also the sale. The learned counsel has also submitted that the permission granted has to be read as a whole, and the learned First Appellate Court has interpreted the documents and the circumstances to come to a finding, and therefore no substantial question of law of this nature is involved. He has relied upon the judgment passed by the Supreme Court reported in 2025 SC on 9 SC 1893, paragraph 18.1, which deals with the procedure to be followed by the High Court on the point under section 100 within bracket 5 of the CPC. he has submitted that, which reads as under 480.1, a substantial question of law must be grounded in the parties' pleadings and the findings of the lower courts. Thus, it must be exercised if it is so fundamental that it goes to the very root of the matter. Inverted commas. You relied upon one more judgment?
Yes, this is 2022
He has also
20
relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2022-20 SCC 1.9
para
para
22.1.
para 32.1.
An inference of fact from recital or contents of a document is a question of fact.
To submit that an inference of fact from recital or content of a document is a question of fact. But the legal effect of the terms of a document is a question of law. Paragraph 32.1 of the aforesaid judgment is quoted as under.
In that
After,
case,
yes.
paragraph 11 is उसमें important है because ये कहते हैं sketch map में है, but recital में नहीं. That has to be corroborated with the recital, that is paragraph 11 of this judgment. Same judgment lordship directed.
The learned counsel for the appellant in response has referred to
Paragraph 11 of the 2007 judgment.
Paragraph 11 of the judgment cited by the
2007 volume 5.
reported in bracket 2007 bracket close 5 SCC 669.
From in between lordship and but when the plaintiff speech bada paragraph है, बीच से paragraph. But when the plaintiff themselves relied upon the sketch to establish, this is what the court has done, lordship. Sketch to establish the properties of the suit, vis-a-vis the existence of lanes and the constructed platforms, etc. It was for them to show that the description of the constructed platform, for them to show description of the property tallies with the one stated in the deed of the sale. This is what I am submitting.
Just to submit that, in the same case, it has been observed that in paragraph 11, when the plaintiffs themselves relied upon the sketch to establish identity of property in a suit, vis-a-vis the existence of lane and the constructed platform, etc., it was for them to show that the description of property tallies with the one stated in the deed of sale. The learned counsel has submitted that it was for the plaintiff to show that while executing the sale deed exhibit 4, it tallied with the permission granted by exhibit 3, right? After hearing the learned counsel for the parties and considering the facts and circumstances of this, however, during the course of argument, it is not in dispute from the side of the appellant that no specific stand was taken in the written statement. However, he has submitted that the parties had contested the suit on this point. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that that it is not in dispute that that the substantial question of law which is being additional substantial question of law which is being raised by the appellant is not grounded on the written statement filed by the appellant. However, the parties had contested had advanced argument in connection with the discrepancy in exhibit 3 and exhibit 4. This court further finds that it's a concurrent finding.
Not yes.
This court finds that there are concurrent findings recorded by both the courts, and the learned first appellate court, while considering this aspect of the matter, has elaborately dealt with the intention of the parties and the circumstances to come to a conclusion that that there was a clear intent to transfer 30 decimal of land, which was duly transferred to the plaintiff by its sale deed Exhibit 4. The findings of the learned First Appellate Court from paragraph
31 to 44.
31 to 44 is quoted as under. This court is of the considered view that, on the one hand, the defendant did not raise any such issue in the
इसमें intention पे एक
any such point in the written statement, but still the learned courts have gone into this point. The perusal of paragraph 31 to 44 reveals that not only the documents but other aspects of the matter have also been taken into consideration to come to a finding that in paragraph number 44. And the discrepancy in Exhibit 3 and Exhibit 4 have also been taken into consideration after reading and referring to the Exhibit 3 and Exhibit 4. This court is of the view that the interpretation of Exhibit 3 and 4 in the present case is essentially a question of fact, and accordingly, findings having been recorded, the additional substantial question of law as suggested by the learned counsel for the appellant does not arise for consideration in this case. IA number such and such is provided.
इसमें तो एक paragraph 34 खाली उधर को दिखाया बस उतना ही सर पढ़ेंगे उधर को समझ में आएगा क्या हम बताना चाहते हैं 4 लाइन का बस but you got that 34. In this connection, it was submitted with learned lawyer for the argument that it was only due to arithmetical and clerical error. This is what they आगे हम पढ़ते हैं वो admit कर रहे हैं कि जो exhibit 3 है उसमें कहीं भी 30 decimal नहीं है या 15 decimals नहीं आगे. As it would be evident from the perusal of the entire exhibit 3, it was also submitted by no document that it was the intention from where this intention has been gathered. It comes afterwards, Lordship, of D3 to sell 30 decimals of land. And he has also applied for sanction to sell 30 decimals of land. वो 30 decimals जो application है, खाली बता दो. वो application नहीं ठीक हो सकता, पर खाली उस point क्या है जो application है that is also not exhibited. वो exhibit होता तो intention वहाँ से gather कर सकते थे. But it is just the order which is only for 1.5.
वो exhibit तब ना होता जब आप written statement में लेते हैं. वो exhibit तब होता जब आप written statement.
That is a secondary question, Lordship. First of all, that Lordship, whatever their pleading is, it has to be established by their own documents.
अब आपको क्या करना है? आपको बहस करना है कि आपको उसको challenge करना है order को?
यही मेरा है और कुछ ही नहीं.
At this, the learned counsel for the appellant submits that that the appellants may decide to challenge this order before the Honorable Supreme Court, and he sees it. हाँ भाई बताइए कब चाहिए आप?
Last week of January.
The execution case has been stayed.
तो pending है second appeal तो फिर January last week तो 96 से 2007 से state था. एक महीना 2 महीना में कुछ नहीं दिया. Only 2 months we are.
Just a moment. The prayer for adjournment has been opposed by the learned counsel for the respondent by submitting that execution proceeding arrived in execution case number.
Last order. It is reflected in the last order. It has been renumbered as execution case number
2-3 renumber हुआ.
29 of 24.
In execution case number 5 of 2006, renumbered as execution case number 2126 of 2023, arising out of title suit number.
This is Lordship.
Title
suit ये है हम दे रहे हैं 116 of 1997.
Title suit number 116 of 1997 has been stayed by this court. To this, the learned counsel for the appellant has submitted that the appellant shall take expeditious steps, if so advised, in connection with the present order.
At least with respect to plot 730, because there is no dispute, it may.
तो है तो आपको छोड़ दिया है. They have left it. वो तो relinquish कर दिया. उसमें नहीं, उसमें execution भी नहीं हो रहा है. उसमें judgment भी नहीं.
However, in order to give an opportunity to the appellant to challenge this order, the matter is adjourned and is directed to be posted on 20th of January.
20.
फिर मैं काम करिए
हम करेंगे, जल्दी ही करेंगे. I think I'll be able to get it done. This way or that way, Lordship, something will.
करना है तो करिए.
नहीं करेंगे, करेगा ही लगता है, because they have no option. घर वर बना हुआ है पूरा वहाँ पे. Till that date, Lordship.
हाँ. Till 20th of January, the interim order granted earlier shall continue. 2006 में आप लोग को 2025 में
वो
आप लोग को होश आ रहा है कि
अभी
revision
वेकेट,
substantial
हाँ
question
वेकेट भी नहीं होता हुजूर तो भी चलता रहता, अभी भी नहीं हो जाता. हमारी गलती. क्योंकि once it is framed, उसके बाद no one bothers, even the client and the advocates also. हमको भी दूसरा फाइल फिर देखने लगता है.
Substantial question of law में बहुत जिम्मेवारी और ध्यान देनी है.
बिल्कुल बिल्कुल.
एरर हो गया तो कहानी खत्म.
बिल्कुल दोनों तरफ से करवाएं.
एक भी मतलब आपका एक केस था लिमिटेशन
Maintainability पे
हाँ
substantial question was answered in my favor, but because there was a finding that the
और
suit is
some
not
other
maintainable. हाँ.
मतलब मेंटेनेबिलिटी या मान लीजिए लिमिटेशन पे कोई फाइंडिंग हो जाए और सपोज कितना ही अच्छा सब्सटेंशियल क्वेश्चन ऑफ लॉ क्यों ना बने, यू कैन नेवर विन द केस इफ दैट बाय itself इज नॉट अ सब्सटेंशियल क्वेश्चन ऑफ लॉ. इतना हमको तकलीफ हुआ था उसको करने में कि ऑल द सब्सटेंशियल क्वेश्चंस ऑफ लॉ वाज आंसर्ड, but ultimately I got grant. Everything goes.
Yes.
और CAB होने के बाद ज्यादा दिक्कत है. फिर हम उसको री-हियरिंग में भी नहीं डाल सकते हैं, कुछ नहीं कर सकते उसका. या I don't remember what exactly happened.
Maintainability.
हाँ.
There was a finding that the suit is not maintainable because the issues were decided against me, and substantial question of law was framed, answered in my favor. But वो findings, because we could not.
There was a cause of action to find.
At that point of time, for some reason, we missed that. We could not point it to the honorable court while framing substantial. Yes. Okay.
From
So
supplementary
Supreme Court गए कि नहीं? नहीं गए.
No.
जहाँ
Both the parties are happy. कोई respondent बोलता है appeal dismiss हो गया, appellate बोलता है कि substantial question अब मेरे favor में.
that also happens. That also happens.
दोनों आपने दोनों को convince कर दिया.
सिविल साइड लॉर्डशिप which we have, हम लोग का एक्सपीरियंस है कि जहाँ ऑप्शनलेस होता है वहीं जाते हैं, अदरवाइज दे एक्सेप्ट. आफ्टर हाई कोर्ट जनरली दे एक्सेप्ट.
I'll tell you one thing. If a party is fighting even for a room, and if he has to evict that room pursuant to some order passed after 30 years of the litigation, initiation of litigation, he would certainly want to exercise one chance.
लास्ट चांस. यस, ये होता है.
तो एक natural है.
Yes. Therefore I said कि ऑप्शन नहीं है then you go. I tried to convince. पुराना deed है, you cannot overcome. This is the only point you have.
from supplementary list for hearing item 4. First
And
appeal
this
to the
deed
6th
was
of
otherwise
2023.
not under challenge. This deed was otherwise not under
No,
challenge.
no.
It is important to note that the sale deed exhibit 4 was otherwise also not in challenge in the suit.
हाँ,
Item 4 from supplementary list.
This one.
Appellant Lordship base. The appellant is a gift of the judgment Lordship where the respondent number 1 has been appointed as a guardian of her sister's minor daughter Lordships. And the respondent is Chacha Lordship, Chacha of that girl child Lordships.
Where is the respondent? Who filed the suit?
Your Lordship, suit was filed by the chacha of that child, and she was the intervener in this case, Your Lordships. She filed an intervener petition, and thereafter the judgment was passed in favor of Tobis, who is the respondent, Your Lordship, chacha. And prior to this guardianship case, Your Lordships, this appellant has lodged an FIR, which she has stated in her intervener petition also, that she has lodged an FIR that forcibly they have taken away the child from her possession, Your Lordships. She was taking care of the child because her sister has love marriage of her sister, and her jija was held. Due to that reason, family of her jija was not concerned with them, so they were residing separate with her Lordships. लेकिन जब उनकी
They
डेथ
were
हो
living separately.
या दे वर लिविंग सेपरेटली, लेकिन जब उन दोनों की डेथ हो गई लॉर्डशिप 2020 में डेथ हुई लॉर्डशिप्स फादर की.
What was the cause of death?
कॉज ऑफ डेथ लॉर्डशिप, कॉज ऑफ डेथ उनको तो बीमारी से, एक को कोरोना से डेथ हुई थी और लॉर्डशिप्स दूसरे की बीमारी से हुई थी. तो और डेथ के बाद लॉर्डशिप विल उन्होंने बनाया था, लेकिन वो प्रोबेट नहीं हुआ था. दैट वाज द रीजन. सिस्टर ऑफ दिस अपीलेंट हैज मेड अ विल कि दोनों मिलके घर खरीदी है और घर भी उन्हीं का है. तो मदर बनाई थी अपनी सिस्टर के साथ मिलके, एंड वो विल बस प्रोबेट नहीं हुआ था, लेकिन दैट वाज द रीजन. और दैट एफआईआर वाज आल्सो नॉट एग्जीक्यूटेड इन दिस
तो
केस.
विल प्रोबेट क्यों नहीं करा?
विल अभी प्रोबेट के लिए पेंडिंग है, प्रोबेट केस फाइल किया उन्होंने. Mother died, father died on 20th January 2020, and mother died on 29th April 2021. And complaint case which was lodged by this appellant on 19th to 2022 against the respondents. And thereafter this guardianship act case was filed in 4th May 2022.
The child was examined.
So,
The child was brought to the court.
no, Your Lordships. At that time she was too young. Now she is 7 years old, Your
What
Lordships.
was her age at that point of time?
At that time she was 3 years, Your Lordships. She was 4 years, Your Lordships. And that criminal case is also pending against them, Your Lordships.
The FIR was executed.
No, Your Lordship, FIR was not executed, Your Lordship. Only will was executed. And the CD in which she has stated that there is some conversation between that girl child and between this
CD, what CD?
CD जिसमें इन दोनों की बातचीत हुई लॉर्डशिप, अपीलेंट और उस बच्ची की, कह रही है कि शी वॉज नॉट ट्रीटेड वेल, ऐसा वो कह रही है उसमें है. और एग्जिबिट में बस हमारी तरफ से विल और CD ही लॉर्डशिप्स एग्जिबिट हुआ. इंटरवेनर पिटीशन में शी हैज स्टेटेड इन पैराग्राफ 10 in page 60 of the LCR, Your Lordships, जो पिटीशन 13 जून 2023 को फाइल हुआ है, उसमें वो क्रिमिनल केस के बारे में उन्होंने लिखा है.
Your intervention was allowed?
Yes, Your Lordship.
It was allowed? Was it allowed?
Yes, Your Lordships.
Bela Bhavanti,
Bela Banu.
Bhavanti. Where is the respondent?
There was a problem in the bill, Your Worship. TW2 has not identified his signature, Your Worship. एक तो प्रोबेट नहीं हुआ था, Your Worship, और दूसरा उन्होंने आइडेंटिफाई नहीं किया था अपना सिग्नेचर. That fact was
The
considered.
CD was exhibited with the 65D certificate.
Your Worship, this has not been stated in the judgment, Your Worships.
बच्चे को बुलाते हैं.
जी,
You would like to interact with the child.
Your Worship, ठीक है.
Till birth. We'll find out. Because welfare of the child is a
Yes,
prime
Your
concern.
Worship.
But where is he? कौन है?
Your Worship.
कौन है वैसे? Who is that? नहीं आएंगे ना, रोज सुनेंगे every day. And I am quite capable of doing this. Okay. FA number 266 of 2023. The learned counsel for the appellant is absent. Nobody appears on behalf of the respondents. The matter relates to the guardianship of a minor daughter, of minor child who was aged
4 years.
4
4
years
years.
at the time of death of her parents in the year 2021.
2023 में Your Worship, 4 years के थे.
क्या आपको होश आ गया?
Sorry, Your Worship.
बच्चा को प्रोड्यूस द चाइल्ड रांची में है, कल लेके आए।
I'm ready, Your Worship. Let's see.
अब जो भी उनके गार्जियन है उनके साथ लेके आइएगा और
Guardian-
वाइफ है उनको भी साथ में लेके
I'm
आइए मत,
yes, Your
बच्ची
Worship.
भी आई है,
बच्ची कहाँ नहीं है?
बुलाइए सर,
बुला दे रहे हैं, Your Worship.
बुलाइए सर।
पास स्लिप बनवाना होगा।
आपका केस है, आपके गार्जियन बाहर खड़े हैं और आप कोर्ट के बाहर, ये कंडक्ट सही है आपका?
Your दूसरे कोर्ट में था, Your Worship. जिनका केस था वो तो
और जिनका केस है उनको कोर्ट के अंदर भी नहीं घुसाए,
मैं वो
किस लिए? यहाँ पे घूमने फिरने आए? यस, टेल अस।
सॉरी Your Worship. सीनियर का केस था जो
कौन है किसी ने?
ऋषि चंदन, he has been appointed as district and session judge बिहार में जो।
तो बच्चा को छोड़ दिया,
नहीं जो हम देख रहे हैं।
बुलाइए उनको अंदर, बुलाइए, उनसे पहले बात करते हैं और कल बच्चे को लेके आए।
जी अभी बुला।
सारा चीज, स्कूल का रिपोर्ट कार्ड, सब चीज आना चाहिए, स्कूल का बैग सब आना चाहिए, कहाँ पढ़ रही है,
जी
फीस पेमेंट,
बच्ची अच्छे से पढ़ रही है Your Worship.
और पता लग जाएगा।
जी Your Worship.
बुलाइए, उनको बुला के लेके आइए अंदर,
उसके हाँ
अंदर लेके आइए तब ऑर्डर करें।
जी बुला।
From day list item 1, 2nd April 131 of 1998.
Who is there in this case?
Yes, sir. Yes.
We had filed one application for reframing substantial question of law and for framing additional substantial question. Your Lordship may see para 6 which we have proposed. The original substantial question of law that was formulated was by the order dated 18/11/1998, and it was whether in view of plaintiff's own case that BP Jumrati Khanum had died issueless, sued for partition at the instance of the originally framed question was so brief fact can I place before your Lordship placing this IA here?
This additional substantial question of law in second piece have become a device to seek a judgment.
No. I say that your Lordship may tomorrow itself your Lordship may.
Additional substantial question of law आ जाता है।
Your Lordship
हाँ,
when
इतना पुराना कब का चल रहा है, 98 से चल रहा है।
हम तो बोल रहे
कभी
हैं
होश नहीं आता है।
हम इसको बहुत पहले ही फाइल किए हुए हैं, बहुत पहले फाइल किए।
कब फाइल?
ये देख लिया है
29/10
8th of
29/10/25 को फाइल। मैंने 8 तारीख का 8 का एफिडेविट होगा।
नहीं 8/10/2025 में
नहीं, एफिडेविट on 8/10, file on 25, 29/10. क्या additional substantial?
Your Lordship may first hear me absolutely very short
पहले
matter.
हमको additional substantial question of law दिखा।
हम दिखा
वो law से related
This is a,
है कि
हाँ
fact से
बता रहे हैं,
related?
this is a case of reversal, and the first appellate court framed these questions for point of determination. So when it frames and it answers against me, that question would naturally arise even in second, because it has reversed the decree passed by the trial court. Very short fact. If your lordship would only allow me to place.
पहले ये substantial question of law
बता।
देखे तो सही क्या बोलना चाहिए? Whether पढ़िए.
हाँ, ये पैरा 11 में जो है दो क्वेश्चन एडिशनल हम बोल रहे हैं, वो ये है वेदर विलायत हुसैन had 3 wives, namely बीबी विलायतुन्निसा, बीबी फिरोजा खानम and बीबी जुमराती खानम, or had only 2 wives, namely
ये
विलायतुन्निसा.
substantial question of law है.
होगा because
Because there is a reversal.
yes, reversal and
Reversal.
answer to this would be would the entire case would.
Maybe the entire case would depend on this, but it is essentially a question of fact.
Question of fact, but your lordship, question of fact.
100% a question of fact.
Absolutely question of fact. But
Merely because there is a reversal, we should.
no.
Then
A question of fact, answer to which decides the entire fate of the case, that would be a substantial question.
the question of fact which decides the entire fate of the case is a substantial question of law. Show me one judge.
I'll show.
Show, please show. I want you to show this judgment. That if a question of fact decides the entire case,
Yes.
that question of fact becomes a substantial question of law.
Because it is pivotal for decide adjudicating.
Maybe, even if
Therefore-
it is pivotal. No. This is not the concept of, please don't.
नहीं, हम I'll cite.
साइट दिखाइए ना, कहाँ लेके आए? आप ऐसा प्योर फैक्ट पर एक एडिशनल सब्सटेंशियल क्वेश्चन.
अच्छा, हम उससे पहले फैक्ट दिखा दे
कुछ
रहे हैं.
फैक्ट हमने देखे, ये सब्सटेंशियल क्वेश्चन ऑफ लॉ है.
अच्छा, इसको सेकेंड
आपसे तो एक्सपेक्टेड.
ठीक है, सेकेंड हाफ रखा जाए. सेकेंड हाफ, your lordship has already a fixed matter at 1. So your lordship may hear me on second half. I'll place.
मुश्किल से एक कंटिन्यूअस 1 साल से बेंच चल रहा है. केस से बहस करिए, ये सब काम मत करिए.
नहीं
किसी का
हम
भला नहीं होने वाला है. अगर मेरा जजमेंट गलत हो तो आप सेट असाइड करवा दीजिए. वो
नहीं,
ज्यादा अच्छा है. ये सब
नहीं.
करके लोगों के मरने का वेट करके.
अरे
क्या
मरने का हम वेट नहीं कर रहे हैं. हम बोल रहे हैं हम आज होगा, कल हम बहस कर देंगे. अगर आज फ्रेम होगा, बट आई हैव टू फर्स्ट शो दैट योर लॉर्डशिप दिस इज इन्वॉल्व्ड. एंड
ये कोई क्वेश्चन ऑफ लॉ है ही नहीं.
ये हम
We just read it, both these.
हम
Whether there were 2 wives or 1 or 3 wives, is it a question of law?
is this question of law, because as I said, your lordship, a question of fact which decides the entire fate of the parties, that would be substantial for deciding the second.
That merely because a question of fact is substantial to decide the case,
Yes,
it does not become a substantial.
I'll show it is my fault because now this is a question of law, that whether this particular ratio is there of the Honorable Supreme Court or not. Your Lordship may hear it in second half itself. I will not.
IA number 1.12.2025 in essay number 131 of 1998 within bracket 3. The learned counsel for the appellant has referred to paragraph 11 of the intellectual application, which is the proposed additional substantial question of law, which reads as follows. On the face of these proposed additional substantial question of law, this court is of the considered view that the same are essentially question of facts and not question of law. At this, the learned counsel for the appellant has submitted that he shall cite a judgment that in a case where the decision would rest upon in question of fact, such question of fact by itself is to be termed as a substantial question. इसी से जन्म।
Tomorrow,
कल लेके आए।
tomorrow.
कल लेके आए।
हाँ कल कल
ऐसा एक हम भी जरा देखें।
नहीं नहीं एकदम एकदम
लेके आइए।
हम होना ही चाहिए
लेके आइए।
my
I will
apologies
change my views on substantive question of law.
ठीक है
यही जजमेंट लेके आइएगा, दूसरा कोई जजमेंट
हाँ हाँ हाँ, कोई और नहीं लाएंगे कोई और नहीं
बेसिक का है दूसरे का।
ठीक है
ठीक है, respondent, are you there? Respondent is there in this case. Counsel for the respondent is present.
From supplementary list space case item 1, first appeal 175 of 2024.
मिला आप लोग को जजमेंट मिल गया? Question of facts.
Madam, there is one judgment. He is right because he has already read it.
So, one judgment which says what? Pardon?
A substantial question of law must be grounded in the parties' pleadings and the findings of the lower courts. Thus, it must be exercised if it is so fundamental that it goes to the very root of the matter. The judgment of Honorable Supreme Court in Santosh Kazari versus Purushottam Tiwari, 2001 3 SCC 170.
No, I'll cite recent also. One line, just line.
Two thousand one three.
3 SCC
2001 3 SCC.
170.
1 3 SCC.
170. In fact, my lord,
179.
9.
This is on at the time of framing substantial.
While
Does it
exercising
deal with
105.
100?
100 subsection 5. और उसको पूरा डिटेल हम नहीं देखेंगे जस्ट
पढ़ेंगे। पढ़ेंगे every day we are learning. आपका नोट कहाँ है?
मतलब नोट थोड़ा सा फैक्ट्स हम नहीं लिखे सिर्फ पर्सिटी ही लिखे हैं इसमें स्पेसिंग की वजह से 4 पेज का एंड जजमेंट्स दो उसमें रिलाई किए इसमें ये वाला भी जजमेंट है
ये वाला जजमेंट सेकंड अपील वाला लगा था।
मतलब उसमें बस एक चीज दिखाना है इसलिए जस्ट इंटरफेरेंस के पॉइंट पर
Santosh Hazara's case is
Para 15, madam, the last 4 lines on page number 13. Where you as a matter of law, if the appraisal of the evidence by the trial court suffers from material irregularity or is based on inadmissible evidence or on conjectures and surmises, the appellate court is entitled to interfere in the finding of the fact.
उन्होंने भी दिया था ना आपका written submissions. The counsel for the appellant, while assailing the impugn judgment passed by the trial court, has made the following submissions. A. The details of the property involved in this case has been projected in a tabular form as under. While referring to the perversity in appreciation of Exhibit 3, the lease deed executed by defendant number, plaintiff number 1, plaintiff number 2 and defendant number 2
One part
in favor of ICICI. It has been submitted that the impugn judgment suffers from patent perversity in as much as the learned first appellate court has, the learned trial court failed to mention that plot number 7217 measuring 2.5 decimal is also included in schedule 1 of exhibit 3. He submits that a bare perusal of schedule 1 of exhibit 3 clearly demonstrates that plot number 7217 is very much a part of the schedule, and consequently such finding is in direct conflict with the document itself, that is exhibit 3. We have submitted that 2.5 decimal of land in plot number 7217 belonged to the plaintiff, number 2, who had joined with defendant number 2 to execute the sale deed with respect to the entire property covered by sale deed number 373 dated 30/12/2003. The during the course of hearing, the learned counsel for the respondents has also not disputed this aspect of the matter, that sale deed dated 2012-2003 included the properties which was mentioned, which has been mentioned in the aforesaid chart, and the property of plaintiff number 2 in plot number 7217 area 2.50 was also involved, was also involved in the lease deed. Lease deed का क्या date?
Release date is 11/8/2016.
Lease deed dated 11/8/2016. Within bracket exhibit. However, it has been submitted by the learned counsel for the respondents that such discrepancy has no bearing in the matter, inasmuch as the matter relates to partition suit and unity of title, unity of possession and nucleus of the joint family is required to be seen, as the properties stood purchased in the name of daughter-in-laws in the family, which was subject matter of partition. The learned counsel for the applicant, while proceeding further to show the erroneous finding recorded in the impugned judgment, has submitted that there has been error with regard to the recording of payment of consideration money for the registered sale deeds, standing in the name of plaintiff number 1 within bracket exhibit 1, and standing in the plaintiff number 2 and standing in the name of defendant number 2 within bracket exhibit 2. He submits that a wrong finding has been recorded that the consideration money under the registered sale deed was paid by the parties from their own source of income, which was well mentioned in the sale deed. He submits that upon perusal of the sale deeds exhibit 1 and 2, there is no averment/recital, no such averment/recital contained in the sale deeds, and therefore the plaintiff number 2 and the defendant number 2 in their respective sale deeds have not disclosed the source of income. The learned counsel has also submitted that the finding is also contrary to the explicit recitals in the sale deed. Inasmuch as the source of fund has not been disclosed, when seen in the surrounding circumstances, ये सही जाएगा, surrounding circumstances, the learned counsel submits that the learned trial court has failed to consider that the proceeds of rent accruing under exhibit 3, the lease deed, were being continuously and equally shared between plaintiff number 2 and defendant number 2. on 50-50 basis. Although the sale deed standing in the name of plaintiff number 2 was for 2.50 acres,
Decimals.
2.50 decimal in plot number 7217, and 21.5
5 decimals.
decimal in the sale deed of defendant number 2, out of which 7.25 was in plot number 7217 and 10.75 was in plot number 7208 and further 3.50 was in plot number 7209. The learned counsel submits that the sharing of 50-50 basis with respect to the rent, in spite of huge discrepancy with respect to title of the leased property, when seen between plaintiff number 2 and defendant number 2, itself demonstrates that they had joint possession over the property, which also demonstrated that the income was joint and there was joint contribution to buy the property in favor of plaintiff number 2 and defendant number 2, irrespective of their actual area mentioned in the respective sale deeds. The learned counsel submits that merely because Exhibit 1 stood in the name of plaintiff number 2 and Exhibit 2 stood in exclusively in the name of plaintiff number 2 and Exhibit 2 stood exclusively in the name of defendant number 2, the sale by itself cannot be said to be a conclusive proof that there was no unity of title and unity of possession with respect to the two properties, that is Exhibit 1 and Exhibit 2. And that the properties were purchased from their individual income. He has also submitted that it was the specific case of the plaintiff in the suit that the properties were purchased from the business income of the business run by the father-in-law of plaintiff number 2 and defendant number 2. And therefore, merely because the property was purchased in the name of plaintiff number 2 and defendant number 2, the same cannot be excluded from the contours of joint family. That's it. क्योंकि आपकी बातों को लिख दिए हैं जैसा हमको लगा कि ये चीज आप बोल सकते हैं.
Absolutely.
Irrespective of whatever you say.
Yes, yes. Absolutely, I understand.
These are the possible arguments that you can raise.
Three of them.
The learned counsel then submitted that the learned trial court has failed to consider the consistent conduct of the parties, which demonstrate jointness of properties. He submits that the plaintiff had specifically pleaded and proved that rental proceeds under Exhibit 3 were equally divided amongst the parties, which was an admitted fact. And despite this undisputed practice, the learned court did not draw the necessary inference that without joint ownership/joint interest, such conduct of the parties is not possible in the facts and circumstances of the case, and thereby the learned trial court has committed serious error in law and fact. He has also submitted that the first appeal is a continuation of suit, and every aspect of fact and law is open for consideration. He submits that error in recording fact can be rectified in the first appellate jurisdiction. The learned counsel then referred to inconsistencies in the alleged inconsistencies in defendant's pleading and evidence, and he submits that this aspect of the matter has also been ignored by the learned trial court. The learned counsel submits that in a suit for partition, every party acquires the status of plaintiff, and therefore it cannot be said that inconsistencies in the defendant's pleading and evidence is required to be ignored, and it is only for the plaintiff to prove his entire case. Correct? Yeah. इतना चीज सोचे हैं आपके केस के बारे में, इसलिए हम लिखा रहे हैं.
Because I was not able to frame this point.
Experience.
Absolutely. About
The learned counsel has pointed out the alleged inconsistencies in defendant's pleadings and evidences, which according to the appellant has been ignored by the learned first appellate court. He submits that defendants in their written statement unequivocally admitted the existence of Ispat Scooters, the firm from which was a source of finance for purchasing the existence of Ispat Scooters, full stop. However, during evidence, DW1 and DW2 took a complete inconsistent stand by asserting that they had no knowledge of Ispat Scooters. The learned trial court has failed to consider the failed to notice this inconsistency, and this has resulted in an erroneous appreciation of evidence and amounts to, which goes to the root of the matter, and the findings recorded by the learned trial court on the issue relating to possession, partnership and source of income is perverse. The learned counsel has relied upon the judgment passed by the Honorable Supreme Court in the case of Krishi Utpadan Mandi Samiti Saswan versus Bipin Kumar, reported in bracket 2004 bracket close to SCC 283 para 7, to submit that the documentary evidence would exclude oral evidence, and has referred to section 92 of the Indian Evidence Act. The learned counsel has then relied upon the judgment passed by the Honorable Supreme Court, reported in bracket 2001, bracket close 3, SCC 179, para 15, to submit that if the appraisal of evidence by trial court suffers from material irregularity or on conductors and surmises, the appellate court is entitled to interfere with the findings of facts. The learned counsel has in particular referred to page 20 and 21 of the impugned judgment, where findings have been recorded, and also to paragraph 16 and 17 of the written statement, and further paragraph 22 and 32 of the evidence falling in cross-examination of DW1, and paragraph 26 of the evidence falling in cross-examination of DW2. यही आपका references evidence है. The learned counsel for the respondents, by opposing the prayer of the plaintiff seeking partition of exhibit 1 and 2, which stands exhibit 1 and 2, which are the two registered sale deeds standing in the name of plaintiff number 2 and defendant number 2, respectively, has submitted as under 1. The suit property consists of 2.5 decimal purchased in the name of plaintiff number 2 and 21.5 decimal purchased in the name of respondent number 2, defendant number 2. While separate registered sale deeds dated 20/12/2003 and 30/12/2003 respectively. The recitals in the registered sale deeds, Exhibit 1 and Exhibit 2, clearly state that the consideration was paid by the respective purchasers. C. The trial court has rightly held that defendant number 2 purchased her portion from her own independent income, and the appellant failed to rebut the presumption of correctness attached to the registered sale deeds. The learned counsel has submitted that since the two registered sale deeds exhibit 1 and 2 stood exclusively recorded in the name of plaintiff number 2 and defendant number 2, who are said to have paid the consideration amount, the same cannot form a part of joint family joint family property which could form subject matter of action. The plaintiff number 2 and the defendant number 2 are not co-partners of the family. ये उनका submission है. They are daughter-in-laws in the family. It has been further submitted by the learned counsel for the respondent that the plaintiffs failed to prove the joint nucleus or joint fund to claim that the Exhibit 1 and Exhibit 2 was purchased from such fund. It has been further submitted that that the plaintiff's entire case rested on the assertion that the consideration money came from the joint income of Ispat's scooter. However, the plaintiffs failed to produce any cogent financial records, books of accounts, or bank statement of Ispat's scooter from 2003 to link the business income to the specific purchases. He has further submitted that rebuttal to demand draft argument within bracket in rebuttal to the arguments to the facts relating to preparation of demand draft. It has been submitted that mere act of a family member going to bank to prepare a draft does not prove the source of money. It has submitted that the trial court rightly appreciated that the source of fund was not proved to be the joint business. The plaintiffs failed to prove that the money debited to prepare those drafts belonged to joint family fund. It has been submitted by the learned counsel for the defendants that the source of fund for preparation of demand draft to pay the consideration money with respect to Exhibit 1 and Exhibit 2 was required to be proved, and merely because the amount has been paid from the through demand draft, the same does not prove that the property was purchased from joint family fund or was purchased from the business income of was purchased from joint business. The learned counsel has then submitted that there is complete absence of unity of title and possession. He submits that the trial court recorded a specific finding that there is no jointness in title and possession. The plaintiffs admitted that the multi-story building was constructed on the land, and the defendants asserted that the construction was made by the defendants. The plaintiffs claimed that the building was built by the father, within bracket Kamal Kumar Kankar, bracket close, but failed to prove through evidence regarding his investment or even the source of fund to construct the building. The learned counsel has further submitted that the tenancy, that is the lease deed as contained in Exhibit 3, which has been heavily relied upon by the learned counsel for the appellants, does not prove the joint title of the property. The mode of payment of rent will not decide the ownership or title. It will not decide upon the factum of exclusive title and ownership with respect to the property. it has been submitted that the two separate owners of adjacent/combined plots can lease their property to a single tenant, as in the instant case to ICICI Bank, and receive rent proportionately. This constitutes co-ownership. This will not make the property a joint family property. They have submitted that the trial court has rightly held that the lease deed exhibit 3 does not prove joint ownership in the sense of a joint Hindu family property. He has further submitted that the learned trial court has passed. He has further submitted that none of the witnesses induced on behalf of the plaintiffs have supported the case of the plaintiffs so far as the claim of, with respect to the claim of the plaintiff that there was unity of title and unity of possession with respect to the properties which could be subject matter of partition in a partition suit. The learned counsel has submitted that the learned trial court has passed a well-reasoned judgment based on documentary evidence within brackets series of 2003 bracket close, and the failure of the plaintiff to discharge the burden of proving a joint family nucleus is fatal to the case of the plaintiffs. He has further submitted that the property is standing in the name of two daughter-in-laws of the family cannot be subject matter of partition, and as they do not constitute a part of co-partnership. He has also submitted that the suit was also bad for non-joinder of necessary parties, inasmuch as the daughters of the family were not made parties in the proceedings. They have submitted that in the evidence it has come that there were two daughters of, क्या नाम है इनका? पिताजी का क्या नाम?
Kamal Kumar.
Kamal Kumar Kakkar, but they are not being made party. An objection was raised in the written statement with regard to non-joinder of necessary parties, but the learned trial court has not claimed any issue to that effect. Correct? अब इसको रिजर्व कर देते हैं. आपका सारा सबमिशंस लिखा है. थोड़ा सा हमको लिखाना पड़ेगा. It will take much time. फर्स्ट अपील में तो सारे एविडेंस लिखाने पड़ते. और कल तो बेसिक फाउंडेशन सब लिखाई है. The judgment is sir. I may give a date for the judgment. I am not announcing the date, but depending upon the time. Yes.
What is your second your case में जो parties को बुलाए थे जो आ गए
कहाँ?
किधर से
क्या नाम है आपका?
तो यस बेग
बच्ची आपके पास है?
जी
कहाँ पढ़ती है?
संत फ्रांसिस स्कूल बनवरा रांची।
उसका एडमिशन स्लिप
कब से पढ़ रही है?
मेरी 2 बच्ची है मैम और करिश्मा है, तीनों एक ही साथ एक ही स्कूल में।
एक स्कूल में। कब से पढ़ रही है?
पढ़ाई कर रही है
कब से
अभी मतलब 1 में है।
अच्छा, अभी जस्ट एंट्री हुआ।
1 में जी।
अभी तो 5-6 साल की होगी।
हाँ अभी 6 प्लस
7 अप्रोचिंग 7 पहुंचने वाली होगी।
6 प्लस 2 साल की थी मैम, बहुत परेशान थी
हाँ।
और ये ऊपर से परेशान करते थे। 4-5 वो केस कर दी थी। हम बच्ची के काम में लगे हैं, ये बाधा करने में लगे रहते। स्कूल में जाके भी परेशान करते।
रेगुलर जाती है स्कूल?
हाँ रेगुलर स्कूल। बच्ची ठीक है
हेल्थ वगैरह सही है?
जी।
सम फोटोग्राफ्स
फोटोग्राफ्स नहीं, हम लड़की को ही देखना चाहते हैं।
हाँ
बच्ची
हाँ
को लेके आए।
हाँ
ले
आप ले आइए और
उनकी
आप उनको
अपनी उनकी वाइफ को भी
अपनी वाइफ को भी लेके आइए।
हाँ वाइफ तो चाहिए बस।
तो आज यहाँ कौन देखता है?
हम देखते हैं और
तो आपकी वाइफ नहीं है उनको देखने?
वो टीचर है मैम उधर।
तो बहुत मुश्किल है।
नहीं हम
The
कर
lady of the family is not there at home.
नहीं आई माँ लोग भी थी मैं
2 और बेटी है इनकी
और
वो
2
भी इन्हीं के साथ रह रही है।
2 बेटी बड़ी है।
साथ में रहने से क्या? वो उसकी माँ को भी बन जाएगी। आपकी वाइफ आपके साथ नहीं रहती है? जिस आपको वेरी सीरियस।
माँ लोग को भी रखे हैं। बच्ची ज्यादातर मेरे साथ ही रहती है।
समझ रहे?
हाँ जो रियल फैक्ट है जो कुछ बता ही रहा है, वो कुछ छुपाना नहीं चाहते, छुपा भी नहीं रहा, जो जैसा है वैसे ही बता रहा। कि बच्ची के फादर का डेथ हो गया था जो 2020 लड़की 2021 में उनकी मदर का डेथ हुआ। उस समय से बच्ची इनके पास ही है एंड जहाँ इनकी बेटी पढ़ रही है वही स्कूल में वो भी पढ़ रही है। वैसे कल ले आई बच्ची
जी।
और आप भी अपने आप कौन है?
मौसी
You are
बच्ची
the
की मौसी।
advocate?
यस
और आप मौसी भी हैं?
यस
आपको ऐसे कोर्ट में नहीं खाना चाहिए इन यूनिफॉर्म।
I'm actually the council lordship.
You are the counsel.
हाँ from the side of मौसी।
उनकी मौसी को भी लेके
वो तो मैं कभी भी देखने नहीं आई है बच्ची।
1 मिनट
दोस्त
बस हो गया, आप बात करें।
बस बच्ची से कुछ बात करेंगे, फिर आप उससे बात करेंगे, फिर सोचेंगे क्या करेंगे। कल लेके आए 1 बजे।
अप्रोचिंग 5 इयर्स से तो बच्ची इनके पास है, पढ़ भी रही है। 2024 में उसका एडमिशन भी हुआ है। फीस उसका सब पेपर भी ले आई है।
फीस तो उसको पेंशन ही इतना मिलता होगा कि फीस का कम होगा।
हाँ बार जो ये दे रहे हैं रेगुलर।
नहीं बच्ची के लिए अभी पेंशन को वही अभी नहीं दे रहा उसको मैं।
अभी उसको पेंशन नहीं चालू हुआ है, चालू नहीं हुआ अभी तक।
पेंशन तो चालू हुआ है पर बच्ची बड़ी होगी तभी निकालेगी बोल के नहीं देता है।
ऑर्डर में है कि जब वो बड़ी होगी तब उसको वो पैसा मिलेगा,
उससे
पहले नहीं।
अभी हम अपना से मेंटेन कर रहे हैं।
कि खुद ही प्राइवेट जॉब करते हैं कि वाइफ टीचर है कि गवर्नमेंट टीचर।
और मौसी क्या करती है?
एडवोकेट।
व्हाट इज हर
एडवोकेट तो जो नहीं थी इन द ईयर 2023 में तो वो मुंशी का काम करती थी नोटरी की तरफ, एज पर माय नॉलेज, एज इंस्ट्रक्शन गिवन बाय हिम। अभी एडवोकेट होगी।
व्हाट इज द सोर्स ऑफ इनकम?
Lordship, I'm not aware. The learning council is actually working downstairs. I have to take